I hope you enjoy it. My intention today is to try to present to you kind of an overview of data breach liability and give you some insights into litigation. It's going to be a little bit on the superficial side because the concepts and these ideas of data breach litigation are new and they're very complex, and we could spend a day on any little small piece of it. So if you have questions today, please stop me and interrupt me. I want to make sure that we're addressing the things that you're interested in, not those things that I'm interested in. And if I don't know the answer, I'll tell you, and we'll do our best to find an answer for you. And I think over the course of this 4-part series, we'll hopefully address all the different parts that apply to data breaches, from the preparation to the response, to notifying folks who have suffered from data breaches, and then also defending a lawsuit if you find yourself in the unfortunate incident of having to do so. So normally when I start, I like to get people standing up out of their chairs, but since you guys all have food in your lap and food in your mouth, I'm going to ask you to give me a show of hands. Who in this room has been personally a victim of data breach or identity fraud or identity theft? Now, keep your hands up. Has anyone else in the room been a part of a company that has suffered a data breach or identity theft? I'm actually surprised we don't have more hands. Keep your hands up. Who in this room is scared to death of data breach and identity theft? Okay, I figured I'd get a better response out of that. That's okay, because data breach scares everybody. And that's what we're here to talk about, is this new concept, and it's a little scary at first, but when you dig down into it, there's some things I think we can help you to do to point you in the right direction to handle data breach litigation. So we're going to cover 3 main topics today. First is we're going to talk about the metrics on data breach liability. And in that regard, what's the empirical data show as far as the incidents, the cost associated with data breach, as well as with the litigation. Secondly, is data breach a problem in your state? We'll talk about North Carolina and South Carolina specifically. That's where I'm licensed to practice. We can also talk about some other states if you're interested. We've got some information on that as well. And then finally, how do you defend a data breach lawsuit? So to get right started, what's a data breach look like? A lot of times people think of a few guys holed up in a hotel room with lots of computers, hacking away at the system. But I want to show you this. Well, hang on. This image here. This is some footage that was taken by the Department of Homeland Security. This was an experiment that was conducted by Homeland Security in connection with the Department of Energy. And they went to a Department of Energy laboratory in Idaho, which is basically a large energy plant. And Homeland Security sent their in-house hackers to try to hack into the system. And this is what the result looked like. And the reason I bring this up to you is that data breach is not just something that happens inside a computer or on a logbook. Data breach can actually end up destroying infrastructure. And if you look at this, they literally blew up the energy plant in Idaho. You can see it, not a good outcome as far as our standpoint from the defense side, or from companies that might be the recipient of a data breach. Now, what is a data breach? In order to talk about a data breach, I want to first begin talking about some different terms that you got to know, sort of the terms of art. And this is all in your materials, so you can follow along. First, personal information or personally identifiable information. This is a major buzzword. This is information that requires both a name and then some additional identifying information that could link up the name with a person's identity. In other words, this additional item is necessary. Just a name is not enough. You got to have something to kind of link them up with their financial accounts or otherwise. We've also, so additional information can include credit card number, social security number, driver's license, medical ID card, or financial account information. So that may be broader than what you realize. Another important term in this area is personal health information, PHI. And you'll see this referenced a lot with regards to HIPAA and HIPAA regulations, but PHI relates to, again, it's broader than you might think, a person's past, present, or future mental health or condition, the provision of health care, as well as the payment of health care. So bills for health care fall within the definition of PHI. So when we're talking about a data breach, we need to also be a little more precise with our terminology. A data incident, I call it a nerd term. It's an IT term. It's something not normal has happened. This is something that your IT folks may find and may report that something appears to be not right in the system. We've got a glitch. A data incident is something different from a data breach. A data breach is actually a legal term of art. It's a matter of interpretation. It's when the nerds look at the data incident and realize, okay, we've actually had someone to infiltrate the system, or we've actually had information that's private leak out into the public sector. And the importance between this distinction is that a data breach is what triggers the requirement for you to notify data breach victims. A data incident doesn't require notification. A breach absolutely does, and we'll get into more of the details of that. What types of breaches are there? There's cyber hacking, hacktivism, cyber espionage. These are all buzzwords that we hear regularly. There's also the unintentional loss of information. You'll see when we look at the empirical data, this makes up a huge portion of data breach, and it can be just as damaging and just as expensive as the cyber espionage. We've also got employee misconduct, as well as bad business practices. I'm surprised when I look on the Federal Trade Commission website how many companies, literally their business model is in violation of the laws that apply to data breach and the protection of personal information. So, business practices alone can be a source of this type of litigation. So what does the empirical data show? I will submit to you that it's compelling. And it's this data that gets me excited about this topic, not because I wish any of you to suffer a data breach, but because when you look at it, you realize that in this day and age, we are using technology more and more every day. Technology is expanding at an exponential rate. The opportunity for data breach is expanding rapidly, and so it only follows that data breach litigation is going to be bigger and bigger and more frequent as we go. So this is a pie graph that's mapping out incidents by breach all time. This was put together by a third-party vendor. The font is small, so I won't go into each of these, but I thought it was interesting. The largest incidents for data breach comes from stolen laptops. So each of you that have a laptop, you might want to think twice before you set it down and go up and get another cup of coffee at Starbucks. That's the number one, followed secondly by cyber hacking. They're about the same. Now, there have been a number of studies that have come out. I'm going to be referring to the 2013 studies. The 2014 studies, for the most part, have not come out. Verizon puts together a huge study, and I can provide you, there's a bibliography in the back. I can provide you with copies of any of these if you want to take a look at these studies because they're very well done. But Verizon said in 2012 there were 621 confirmed data breaches in this country and 47,000 reported security incidents. Remember, we talked about a data incident versus a breach. This is actually, from 27 different countries. The one thing I will point out is each of these studies is very good in its own right, but they all have discrepancies. The numbers sort of fluctuate, and I think it depends on the subjective definition of a breach and what falls within the parameters of their studies. But I think the overwhelming message that I take from these is that the numbers are high, and they're getting bigger and bigger and bigger. 37% of the breaches, according to Verizon, occurred in the financial industry. A quarter of them occurred in retail. Now, Net Diligence did a study in 2012. This is a cybersecurity firm. They said in 2011 there were more than 850 security breaches. In 2011 there were more than 170 million confidential records compromised. The average cost per breach was $3.7 million. If that doesn't get your attention, The average cost of defense is approximately $500,000 to defend a case, and the average settlement with a putative class is over $2 million. So when you look at the number of breaches and the number of records, you can see that data breach litigation and data breach liability can be very, very expensive, and it's something that we need to get out in front of and think about proactively instead of reactively. Now, Ponemon Institute, along with Symantec, has sort of the seminal benchmark study in this regard. And this is they actually did the 8th study on this topic in 2013. And I'm going to click through these quickly. The global average for a breach is between $100 and $136 per record. 2012, the average was $188 per record. 2012, the most expensive breach was $277 per record. The average cost in 2012 in the U.S. was $5.4 million per breach. The number of breach records, the average in 2012 was almost 30,000. The cost of detection, I thought this was interesting, was $1.3 million. There's a whole industry, and Serge from the Silent Group will come in and tell you next time about this, but just going in when you've got a data incident and determining that it's not only an incident but it's a breach, and then taking it from that point and then notifying your customers of the breach is an extremely lucrative business for these guys that do this. And it's very costly to those of us that have to rely on them. So, I mean, just imagine each breach, it costs you $1.3 million just to determine that you have a breach. And then finally, the notification cost, again, almost $500,000. So again, the cost well before you ever get to litigation is pretty astronomical. And again, according to Ponemon, the highest incidences of breach are healthcare and financial industries. Now there's a white paper put out by Aon. These guys, Kevin Kalinich and Steve Bridges, are sort of the gurus with Aon that deal with cybersecurity. Kevin's in charge of global, and Steve is in charge of the U.S. And I've gotten to know these guys through my work in this field. I will tell you, if you're wondering whether your company is keeping up with the reasonable standard practices for data security, it's the insurance guys that know. Because these guys, their job is to measure risk. And their job is to underwrite risk and then insure risk. So if you have questions as to whether you're up to the to what would be considered the status quo or the state of the art, these are the guys that can tell you. I could go into a full hour on insurance coverage for data breach. But in these days, data breach is not something that's part of your general GCL coverage. In fact, there's exclusions in most policies now. So you've got to actually purchase data breach liability and endorsement on your insurance. And in order to get it, these guys are going to come in and underwrite your company and look at your security practices, look at what kind of emergency incident response you have in place, and they're going to measure it all out against what is the status quo. And they'll tell you if you're up to par. If you're not, they won't write it. And they'll tell you what you need to do to improve your systems to get to a point where you can get the insurance coverage. But that's a little bit of an aside. I only tell you that because these guys, truly, of anyone I've spoken to in the field, these guys know what they're talking about. In this white paper, they point out the world's data is expected to grow 50-fold in the next decade. And at this point in time, the world's cyber insurance premiums are only $1.3 billion. That sounds like a lot of money, but when you compare it to non-life insurance premiums for all other types of losses, it's a 1 to 667 ratio. And what these guys say is that today businesses place a much higher value on data and intangible assets. However, when you look at the way that the businesses are insured, the insurance is out of whack. In other words, people are not insuring against these losses the way they should. And with the incidence of these breaches just on the upswing, it's just that much more important for us all to look at this carefully and make sure that we're properly protected from a security measure standpoint as well as from an insurance coverage standpoint. Now, Data breaches, I'm sure you guys have read all about these in emails and in newspapers, etc. They've hit major companies like Heartland, Dave & Buster's, TJ Maxx suffered breaches. Somewhere in the neighborhood of 70 million credit cards were compromised with the TJ Maxx breach. I'm not going to go into this, but this issue, it's on 60 Minutes. It's on the front page of every newspaper. Data breach was the subject of a White House executive order at the beginning of 2013. President Obama also talked about it at length in his 2013 State of the Union address. But what he put in the executive order was that there was basically a mandate to improve the Critical Infrastructures Protection Act of 2001. And he mandated that this country identify the threats, come up with the most serious national security threats, and then put into place certain parameters and certain guidelines, best practices that could be used in order to protect against a breach. And in fact, in February of this year, this was put out, the Framework for Improving Critical Infrastructure Cybersecurity. These were guidelines that were developed by the NIST. They're not requirements. It's not a law that mandates that you actually follow these guidelines, but it provides a good measure for folks to look at and compare what you're doing from a data security standpoint and with what's being recommended by the National Institute of Standards and Technology. So the President asked for it, and then a year later he got it. So let's talk about a couple of breaches. You guys all may be familiar with what happened in South Carolina a year or two ago. The Department of Revenue suffered a major breach of customer records. I was one of the victims of that breach. And if you look, the stats on this, it occurred in between August and September of 2012. The hackers accessed the DOR database. They used 33 unique and undetected pieces of malicious software. This was a very sophisticated hack. This was not something that was done by amateurs. 3.6 million social security numbers were stolen, and almost 400,000 credit card numbers were stolen. 6 million taxpayers were affected, and the amazing thing to me is it was not detected until about 60 days after the breach started. So there were 60 days of just unfettered access to this personal information before the Department of Revenue shut it down. The victims all received written notifications. We've all received free credit monitoring. It's just about expired. South Carolina extended the credit monitoring for another year. But this is a huge expense. In the 2013-2014 fiscal year, the South Carolina, I think they appropriated approximately $20 million to create a fund to deal with liability rising out of this breach, as well as implementing new security measures. And this $20 million price tag is just going to be continuing. This is just the tip of the iceberg. We're all familiar with Target, I'm sure, and I've talked to some of you beforehand today, and Target is obviously a hot button issue right now, and it's gotten a lot of press and a lot of attention. If you look at the data on the Target breach, it occurred between November and December of last year. Target estimates that 70 million customers were affected, and the compromised data includes a large number of things. Target first became aware of this on December the 12th and then confirmed it on December the 15th, and the company publicly acknowledged the breach on December the 19th. Now, Target's got a number of problems that are going on. I think there have been approximately 70 lawsuits that have been filed to date, many of them class actions. And so their litigation costs and legal expenses are just getting ready to go through the roof. But one of the problems that Target had, and we're going to get into breach notification, is they've completely botched the notification to the potential victims of the breach. The tricky part with a breach and with breach notification is that you must comply with the notification laws for the state where each breach victim resides. And at this time, 46 states have 46 different breach notification laws. And so Target was trying to juggle those balls, and I honestly think rather than trying to comply with all of them, they decided to comply with none. And as far as I can tell, the breach notification that Target issued was purely by email. And so they've got their own problems with litigation, but this breach notification issue is only going to complicate that. So let's talk about reporting and how does reporting work? What are your reporting requirements? Because even though a lawsuit has not been filed at the time when you discover a data breach or a data incident, it's critical that you know the laws that apply and that you know exactly what you need to do and what the time frame is. So we'll look first at South Carolina. This applies to any person conducting business in the state, and it states with typical mandatory language, shall disclose a breach of the security of the system to any of the following, and it goes on and on. So it's mandatory reporting. The law goes on to say that it must be made in the most expedient time possible and without unreasonable delay. Now, I'm going to step away for a second and get on my soapbox about this. You will see some metrics at the end of this talk that measure out the most important drivers in data breach litigation. One of them deals with how quickly you notify breach victims. The interesting thing is it's counterintuitive. If you notify your victims too soon, it appears that that has a negative outcome on your litigation. And what the studies have shown and what the litigation has shown is those companies that are too quick to fire off a letter, dear customer, we don't know what's going on, we think all of your personal information has been shared with terrorists, we don't know what's going to happen next, stay tuned. You know, mass pandemonium, you know, everybody freaks out and no one knows what to do. The better play is for these companies to stop, take a deep breath, wait 30 days, 60 days, 90 days, make sure they've got their ducks in a row, they've determined what breach occurred, when it happened, what steps they're taking to remediate the breach, and those steps that they are taking to protect the victims. So with that measured approach, you have to weigh that against this law that appears to say you must do it as soon as absolutely possible. I recently was dealing with someone who suffered from a breach in South Carolina, and that was what I spent most of my time dealing with, was trying to slow them down and make sure they didn't fire off a letter too quickly and without enough forethought. Now, let's look at the North Carolina breach notification law. It's basically the same thing. You see, any business that provides, that owns or licenses personal information for residents of North Carolina shall provide notice of the breach. Now, you'll see in red here, in North Carolina, it says whether computerized, paper, or otherwise. So in North Carolina, you've got to provide notification of a privacy breach, whether it's computerized or not. And the reason that's significant, and North Carolina made it exceedingly clear in the statute, is if you go back and compare to South Carolina, look at the language South Carolina used, and unfortunately it's not clear. Shall disclose a breach of the security of the system following discovery or notification of the breach in the security of the data. What does that mean? Is that dealing with computer data or paper data? It's difficult to tell. The statute actually defines breach of the security of the system as dealing with computerized information. However, the statute does not define what this phrase means, breach in the security of the data. There's no case law that talks about it. There's no authoritative information that I've seen published from anywhere that gives guidance on this issue. My recommendation would be, in South Carolina, just like in North Carolina, if you suffer a breach, whether it's computerized or otherwise, you need to comply with this statute. You need to comply as soon as possible and provide notice to the victims. Now, Florida is the other side of the coin. The Florida statute, and I don't have it as a part of the materials here, actually states quite clearly that the breach notification law does not apply to paper breaches or to non-computerized breaches. So all this is to tell you, each state is a little bit different. and you need to make sure that you understand which state you're operating in, and if you have a breach, that you're complying with those breach statutes for the state where the victims reside. It doesn't matter where your company is located. It matters where the victims live. Now, the North Carolina breach notification law also includes something unique. It states that a violation of this section is a violation of GS 75 1.1. That's the Unfair and Deceptive Trade Practices Act. And for any of you that have been involved in litigation before, unfair and deceptive trade practices can give rise to treble damages and the award of attorney's fees. So treble damages is a tripling of damages. It's a punitive measure, as well as the award of attorney's fees if the plaintiff prevails against you. So in North Carolina, if you do not comply with this breach notification statute, you're looking at triple damages and attorney's fees. Now, the only good news that I can tell you on this is that there have been no cases where companies have been hit with unfair and deceptive trade practices, treble damages of the sort with respect to the breach notification law. But these cases, the Fisher case and the Owens case, both apply this unfair and deceptive liability to a similar statute that deals with the protection of Social Security numbers and Social Security information. So I wouldn't mess around. I think in North Carolina, it states it pretty plainly that unfair and deceptive trade practices will apply if you fail to comply with the statute. So I wouldn't want to be the company that tests it. As I said earlier, we've got, in the 50 U.S. jurisdictions, we've got 46 states that have different breach notification laws. The jurisdiction applies to the state where the victims live. I've got here a hyperlink, or at least you can write it down and type it into your browser. This is a list of all the different state breach notification laws. This is something good to keep handy. I've used it a number of times. Obviously, they're forever changing, but at the time, as of today, I believe this is up to date. This should be a good guide if you have to get outside of North Carolina and South Carolina.
Who publishes that?
Who publishes this?
NCSL, do you remember?
That's a good question.
That's a good resource. I had one, but it didn't look like it was up to date.
It's
I can.
National Council of State Legislatures.
Okay.
Okay.
So I think it's a good guide. It's a great place to start.
Okay.
I wouldn't recommend just relying on that information, but it'll give you a list, and you know the states that have the laws, and you can know where to go to find them. Yes, sir.
Is there, excuse me, is there anything concrete on international laws if your business sells or interacts with other businesses overseas, say, and there's a data breach? What type of
Well, it gets that much more complicated when you get international.
Okay.
The EU has come up with a number of guidelines to try to address this issue. There's a safe harbor under the EU. However, I'm not sure how safe it is. They're continuing to try to increase the threshold and make it more difficult to comply with the EU standards. So, unfortunately, I think you have to look at each case on a case-by-case basis. But I think without question you need to be aware of the international laws, the other countries' laws that apply, and make sure that to the extent you can, that you're complying with those as well. It's a really good point, and that's a good segue. The FTC, among other agencies in the U.S. right now, and a lot of congressmen are pushing to try to come up with a federal breach notification law that applies across the country. Because it's gotten so onerous, because it's gotten so difficult to navigate the 46 different data breach laws and making sure that you're complying with each one, there's a big push to try to federalize it. It's not something that would ordinarily happen, but I think in this particular instance, given that data breach has become such a hot button, I wouldn't be surprised to see a federal breach notification standard come forward. And there's the legislation right now is in flux. There have been a number of proposals. Nothing that I know that's necessarily going to be voted in this year, but I would definitely keep an eye on that, and it would certainly improve things if there was one standard that we could all comply with. Now, I'm going to flash through this quickly. I've got some data from South Carolina, some data from North Carolina. This is a graph. You can't read the information on the bottom there on this slide. I apologize. But the one thing I want to show is that when you look at it on this graph and the way it's got the years outlined, there appears to be sort of a downward trend. 24 data breaches in 2010, 14 in 2009, 12 in 2011, and then the first year being 2008, there were only 6. So it appears that maybe perhaps data breaches are on the decline in South Carolina, but when you look at this next slide, the number of affected persons rose exponentially between 2008, 2009, 2010, and then 2011. Interestingly, in South Carolina, by far the greatest number of affected residents were those folks who experienced a data breach in the healthcare industry. And here we go again. Again, this is just another graphic that shows that healthcare in South Carolina was what was affecting the most consumers in the time frame that was reported. Now, this was all before the South Carolina DOR breach. So very quickly, we're going to have new metrics, and these numbers, instead of 300,000, are going to be more like 9 million. And virtually everybody in the state will have been affected, and then some. We've got similar data from North Carolina. This is from the Department of Justice. This is all their known breaches from 2006 to 2013. A couple of interesting things. You can see stolen laptops accounts for a large number, but the release and the display of information is what typically has been the highest incidence of data breach. And that is sort of inadvertent lost data. That is not data that's been hacked or stolen.
Can you give some examples of that? I'm not sure what all that means.
Absolutely, and we're going to get into some case law. Some of this just deals with lost laptops, lost servers. There are a number of cases where IBM, I believe it was, lost some servers in transit. It was unknown who took it and where it went. It may not even been a result of a breach, but this is really more the inadvertent release of information, or also in the accidentally publishing information on the internet, or making information available that's not encrypted or that's not password protected, so as anybody could come into your website and find out Robert Sumner's PHI. Again, if you look in North Carolina, general business makes up the most of the data breaches in this state, followed by a close second by financial services, and then healthcare is a third. And then this just shows you the number of North Carolina residents affected, and you can see the number of North Carolina residents over this time frame. The vast majority come from general business, followed by financial services, and then government in the third spot. So let's talk now, with this being the backdrop, with you having some understanding of the terminology and some of the empirical data that is available at this time. Let's talk about what a data breach lawsuit looks like. My first question is do data breach lawsuits get filed in federal courts or state courts? Well, the answer is both. Depending on the situation, they've been filed in both. South Carolina has a number of lawsuits that have been filed in state court with respect to the DOR breach. Typically, we're seeing these take place in federal court. Most of the big cases are major multi-state class actions, and so they'll occur in federal district courts and oftentimes multi-district litigation. Class actions versus small breaches. The preeminent number of cases up to now has been class actions. Those are the ones that get our attention. Those are the ones that make the headlines. But I will say, based on my research and based on the data that I have seen, these small breaches are occurring with greater frequency every month that goes by. And these small breaches can be just as expensive as the big breaches. It still requires a forensic team to come in and determine that a breach occurred. It still requires a company to go out and notify victims of the breaches. And it requires a response. Stop the breach. And then if litigation occurs, it can be just as complicated because the issues are the same. and we're going to get into the causes of action and the damages that apply. So just because you think you have a small breach, it's not a big deal. I would beg to differ. I think these small breaches are becoming just as much of a problem. I think they're beyond nuisance now. I think they're just as big a problem as the class actions. Consumers as plaintiffs, clearly the class actions are made up of the consumers. I mean, that's just understandable. Folks who own credit cards, folks who've had their personal health information stolen, that's the standard class action setup. But we're also seeing an emergence of banks and credit cards as plaintiffs. And as a defense lawyer, as someone that defends companies and this kind of thing, this is what starts to scare me. Because when you've got Visa and American Express and MasterCard and their armies of lawyers coming after you to try to recover the $50 million or the $100 million that they had to refund the victims of the Target breach, you're talking about some real money at stake and some real serious lawyers and real serious law firms. And so these cases are becoming very, very dangerous as well. For a long time, it was the plaintiff's bar that we all hear about, sort of the mass tort personal injury bar that was pushing these cases. And they were trying to come up with ways to get these cases through motions to dismiss, through the initial defenses that were being put up by the defendants. And they weren't having a whole lot of luck. But I think as the level of sophistication for some of these plaintiffs, and then consequently the level of sophistication of their firms grows, they're having more and more success at sort of coming up with new innovative ways to get these lawsuits to verdict, or at least get them to a point where the cases are being settled for major, major money. So, what types of cause of action can you expect in a data breach lawsuit? Clearly, negligence. And negligence would arise from a duty to protect your customer's information. And if you breach that duty, and there are damages that are resulting therefrom, negligence would apply. There are breach of contract causes of action. A lot of the protection of personal information and personal health information is dictated by contract. And that would especially apply to the banks and the credit card companies when they're coming in and suing. Most of those causes of action are based more in contract than they are in tort. Negligence per se, I want to talk about this at length later. I will tell you that plaintiffs are trying to take the position that violations of legislation, state and federal statutes should apply and provide a basis for liability. I will tell you, thankfully, most of these statutes do not include a private cause of action, and therefore there really are no damages that can arise from a violation of these statutes. But nevertheless, these cases that are being pushed along, they're trying to point to a violation of HIPAA or a violation of Graham-Leach-Bliley to say these folks did not comply with these statutes, therefore this is negligence per se. Did you have a question? Or are you just stretching? Okay. Unjust enrichment is another cause of action that's been used. Breach of fiduciary duty. That doesn't apply in every case, but there are certainly cases where you're going to have a fiduciary duty with your customer. Unfair and deceptive trade practices, like we talked about. In North Carolina, it's a mandatory cause of action under the breach notification laws. But there are also plenty of other states where breach of personal information and a failure to implement a proper security measures to protect personal information could be considered unfair and deceptive trade practices, which again would result in treble damages and the award of attorney's fees. So it's scary. People are seeking injunctive relief, specific performance. This is particularly the case with the enforcement actions that have been filed by the FTC or Health and Human Services. Most of what they can do at this time through the regulation of the statutes is to enforce injunctive relief or specific performance. And then if your company fails to abide by those orders, the injunction orders, then they can go after you for monetary damages. Now, there's some new innovations, as I alluded to earlier. One of the first is using negligent misrepresentation as a cause of action. And this is where the plaintiff comes to you and says, well, you told me you were going to safeguard my personal information, I believed you were, but you knew that wasn't the case. You didn't really have a state-of-the-art security measure in place. I thought I would never have done business with you if you hadn't assured me that my information was safe, and now it's been breached. And so negligent misrepresentation is a cause of action that has been used, and it has been used successfully. And these next two, breach of warranty and strict liability, if anybody in this room deals with products liability litigation, this should ring a bell. This is the new wave. These lawyers have been trying different angles to get through these initial defenses, and they're now trying to apply products liability law to privacy and data breach. I don't think that there has been a verdict rendered that applied breach of warranty or any kind of a strict liability in any setting. But it's this type of innovation that may help them to get past these threshold defenses, get into discovery, and the cost of discovery in these cases could be monumental. And so companies that are facing years of discovery and a possibility that they could face strict liability are saying no thanks and settling the case pretty quickly. So keep your eye on that. That is not something that has really stuck yet, but I have a feeling that they're onto something with these causes of action. This could be something that we could see development in the future. So what kind of damages do the plaintiffs seek? Unauthorized charges on their bank accounts, credit cards, increased risk of future harm. We'll talk about that and whether or not that's actually a recognizable damage or a damage that you can recover on. Damage to credit ratings, cost of credit monitoring, cost of replacement of credit cards, the time and expenses to investigate, anxiety and emotional distress, and unjust enrichment damages. Now, the anxiety and emotional distress brings up something that I will touch on in a little while as well, and it deals with this tension between causes of action in tort and those causes of action that are based in contract. And at this point, no one has had a whole lot of success in arguing anxiety and emotional distress. I'm not aware of any verdicts that have been the result of that, but they are pled in almost every case, and it's certainly something that we need to keep our eye on because it doesn't take a lot of imagination. In virtually every single data breach case, any plaintiff could come in and claim that they're anxious or distressed about the potential risk of future harm. And if that can get them through the gates, then we're in trouble. And the plaintiffs, again, are sophisticated and they're getting more sophisticated. They're using expert witnesses to measure these damages. They're using expert witnesses to measure damage to credit ratings, time and expenses to investigate. They're having doctors come in and testify about anxiety and emotional distress. And so they are putting up cases that are not just they're not just throwaways. They're actually investing time and effort into them. Now, I will say the good news in all of this is that the defenses that are being raised, for the most part, have been successful at either stopping these cases before they start, at a 12B6 motion or a motion to dismiss, or slowing down the cases so much that they settle fairly early on. The first defense is standing, and this is a constitutional defense, and we'll get into the exact standard. The second key defense is a failure to state a claim under 12B6, and there's a fairly exacting standard that applies in federal court. It's a little bit lower of a threshold in state court, but 12B6 is another viable defense. The economic loss rule, defense is based on the standard of care and whether or not the company actually adhered to the standard of care. Negligence per se, again, I said that there's no private causes of action with respect to negligence per se. So let's talk about standing. What is standing? Plaintiff must show that they have met an irreducible constitutional minimum of standing. What does that mean? That they've suffered an injury in fact, that the injury is fairly traceable to the challenged action, and that it's likely as opposed to speculative. And there are a number of cases that deal with this. This is the first line of defense. And so let's look at sort of the way that the courts have ruled. But the courts in general have said that the potential risk of identity theft or the potential for future loss is not enough. It's not an injury in fact, and therefore there is no standing. Now you've got the Hammond versus the Bank of New York case. This is a case dealing with lost laptops. And the court said they didn't have any standing because there was no injury beyond just this fear that something bad might happen in the future. In Riley versus Ceridian, again, this is dealing with lost laptops. And the plaintiff's decision to incur cost to protect against an increased risk was something they did voluntarily. And the court said, no, you don't have standing. You don't have damages that arise to the constitutional level that's required. Also in Whitaker versus HealthNet of California, this is a case involving IBM, and IBM lost 4 servers in transport. Same thing. They had no standing based on just the loss of data alone. There was no demonstration, no evidence of any harm that had occurred at that time. So all of these are dealing with lost data. So keep that in mind. There are some cases that have gotten past the standing threshold. If you look at the Krotner versus the Starbucks Corporation, in this case, this is dealing with the actual theft of information. 2 laptops were stolen and nearly 100,000 Starbucks employees' information was compromised. And the court said, well, in this case where the laptops were stolen, and again, remember, we're in the Ninth Circuit, we're in California, they said, well, generalized anxiety and stress is enough to get you past this standing threshold. Similarly, this is in Florida, Resnick versus Avmed. Again, in Resnick, they were dealing with the theft of information. This was the theft of stolen laptops. 2 laptops were stolen and 1.2 million employees' information was compromised. This was a major case. It just recently settled like the end of last year. It was important because the courts determined that they did have standing based on the threat of future harm, but also because they could actually demonstrate they'd suffered some monetary damages. And in particular, they were able to show that that some of the victims had accounts that were opened in their name, that they were unauthorized purchased from their accounts, and that some had addresses changed that were unauthorized, and then there was a handful of them that had actually E-Trade accounts that had been opened in their name. So the court said in that one, the information was stolen, there's this risk of future harm, and there's also a demonstration of actual harm. This is enough to get you past standing. And so Avmed settled. And then in Holmes versus Countrywide, again, the court looked at this increased risk of identity theft. Interestingly and ironically, given that it was countrywide, some of the victims actually were denied loans and mortgages to purchase homes because their credit had been adversely affected. And then others had folks that actually used their information and went out and obtained loans in their name. And so the increased risk with the actual harm that was demonstrated in combination with the fact that this information was stolen was enough to get them past this standing threshold. So if you get past standing, the next line of defense is this motion to dismiss under 12b-6. This is a failure to state a claim upon which relief can be granted. And in other words, and the standard is plausibility. Is there a plausible grounds for relief that's stated in the complaint? The easy way to look at this is to think about whether the plaintiff has argued or asserted a cognizable injury under the applicable state law. So you have to look at the actual state and where this is applied. Even if it's filed in federal court, they're going to apply state law in order to determine if it's a cognizable injury. What you've got to basically establish that there is a nexus between the breach and this injury that's being alleged. Most of the courts have said that even if you get past standing on a risk of future harm, at a 12b-6, the risk of future harm is even that much more of a no-no. And that without a demonstration of an actual monetary loss, there is no cognizable injury under 12b-6. So if you look at some of the cases, we've got the Piscota case. This is in the 7th Circuit. In Piscota, the court said that risk is not enough under Indiana state law, and that money spent for credit monitoring or to prevent the possibility of future loss was not enough under a 12b-6 standard. Now in Warricks versus Met Assets, we had a stolen hard drive, and again, the court said that we understand the hard drive was stolen. However, they were only dealing with the risk of future loss. There was no actual monetary loss, and the court said, no, we're going to dismiss these causes of action because they failed to meet the threshold for 12b-6. Now the Holmes case, remember we just talked about Holmes, they were able to establish standing to get past the first threshold, but when they got to the 12b-6 level, the courts said no way. They said plaintiffs' payments for credit monitoring services, telephone cancellation fees, and time for credit monitoring were not cognizable injuries to support claims. So when you kind of think about standing is the threshold here, but if you get past standing, the 12b-6 threshold is even higher. And you know, this is all very technical, and I don't know if everyone in this room is a lawyer or not, but the important thing to realize is it's critical if you're facing data breach litigation to mount a very vigorous defense from the very beginning. You can't sit back and wait and see how the chips fall. You've got to get out in front of it. You've got to assert these defenses, and I'm sure whatever law firm you hire will, but they've got to aggressively pursue them, because if they don't, if they get past standing and they get past the 12b-6, then you're looking at years of expensive discovery, and that's not what any company wants to be bogged down in. Now there are some 12b-6s that were allowed, and I think this was, Killian was in Maine, and in Killian the court said, yeah, again, risk, excuse me, this was the South Carolina case, and this is the only South Carolina case I could find. I couldn't find any in the Fourth Circuit, but in South Carolina, in a bankruptcy setting, the court said risk alone is not enough to satisfy a cognizable injury under 12b-6. So we at least got some guidance within the Fourth Circuit and with the South Carolina District that says risk of future harm alone is not enough to get you past the 12b-6. And then the Anderson case, which is next, the court did find, this is the main case, that reasonable mitigation costs plus unauthorized charges is enough to demonstrate a cognizable injury. So I talked about the economic loss rule. What's the economic loss rule? This is a rule that stands for the proposition that a plaintiff cannot recover in tort when the damage is purely an economic loss. In other words, if the plaintiffs here are only alleging an economic loss, charges on their bank account, credit, damaged credit, that kind of thing, they cannot recover for a tort claim. What's a tort claim? Negligent misrepresentation, general negligence, possibly unfair and deceptive trade practices. This is a defense that has been used a great deal. In South Carolina, the economic loss rule is very strict, and it is strictly adhered to as well. Contract law protects the expectancy interest of the parties, and it's tort law that protects the safety interest. So if you had personal injury, that kind of thing, you can recover in tort. You can't recover economic damages in tort. The standard of care, again, this is a defense that gets more into sort of a fact-based defense, but once you get past the 12b-6, you're looking at, did we do enough? Did our security measures do enough to protect the privacy information that's in question? What's the standard of care? How do you define it? This is typically something that is established by expert testimony. The NIST guidelines are certainly going to be used and referred to determine whether companies are complying with those. There's also, in the credit card industry, the PCI DSS. Those are mandatory contractual terms that all credit card users or handlers must comply with. That's another document or measure that is used to determine whether standard of care has been complied with. The interesting thing about the PCI DSS is that as of 2013, 96% of all lawsuits that are alleging a violation of the PCI DSS, 96% of those companies involved in those cases failed to comply with the standard of care that was dictated by the PCI DSS. So if you have a company that actually handles credit cards, uses credit cards, it's imperative that you actually look at those standards and comply with them, because if you suffer a breach, that's the first exhibit that's going to come out in the hands of the other lawyer. And if they can prove you didn't comply with those standards, they're going to be on their road to proven negligence and to recovering against your company. And then, the standard of care is industry specific. It depends on whether it's a bank, a medical provider. Each industry has its own nuances that must be complied with, and expert witnesses are used to demonstrate whether you've complied or not. Yes?
When you say handle credit cards, you mean accept credit card payments?
Yes, exactly. Exactly. There's the PCI DSS. And I've got a copy of it if you'd like to see it. It'll put you to sleep. Now, negligence per se, I alluded to that. Plaintiffs are pointing to failures to comply with breach notification laws and privacy laws as negligence per se. Most of these laws do not have private causes of action, so they can't be used as a measure. But they are being enforced by the FTC, by Health and Human Services, and in cases prosecuted by DOJ. So these laws, the breach notification laws, and the other laws that apply, statutes that apply on a federal and a state basis, you need to be aware of those that apply to your particular industry. And now I'm kind of running short on time, so we've got Graham-Leach, Bliley, the FTC has the red flags rule, there's the FTC health breach notification rule, SEC has guidance that they've put out. I will say this is very interesting. This deals with reporting of public companies. There are requirements, and they're pretty strict, and the SEC is enforcing these requirements. If you have a data breach or a potential data breach issue or information security issue, it's imperative that you report it if it arises to the threshold that's dictated by the SEC. And I've got some information in the packet in front of you. I'm not going to spend time going through each of these, but you can look at them to determine in a general sense whether your company would fall within these. HIPAA, high-tech, guidelines for safeguarding credit union members, and then state insurance departments. Also, they all have their own sets of rules and regulations that deal with the security of personal information and personal health information. And I'm going to just click through here. You can just see we've got some information on this. I'm not going to spend time going through it in too much detail, but it's all in your package. Okay. And I do want to just spend one quick second talking about liability under the Federal Trade Commissions Act. There's a Section 5 of the Ftc Act applies to unfair acts or practices by businesses. I will tell you that FTC is taking a very aggressive stance on their ability to enforce Section 5 and to go after companies who have suffered data breaches on the basis that they have acted unfairly under the Ftc Act. This has been challenged in a number of courts, and all of the opinions that I have read, those that are issued at an administrative level by the FTC and those that have been issued by the courts of the United States, have all said clearly, without question, the FTC has this authority, and they are making it a major frontline area that they are seeking to try to enforce, and they're doing it very aggressively. The FTC, there are a couple of unfairness factors that apply here, and you can see they deal with this on a case-by-case basis to determine whether an act actually falls within Section 5. But I caution you, if you have a data breach, this is something you need to consider. You need to work with the FTC. Most of the cases, I think the FTC has entered into about 70, let's see if I've got that number. I think it's 70 settlements in the last 2 years dealing with the breaches of personal information. Another point that I'll raise is that under Section 5 of the Ftc Act, the threshold defenses are a little more relaxed. And so while you might be able to beat a plaintiff at standing or beat a plaintiff at 12b6 in a court of law, if the FTC is chasing after you, they may have the ability to come after you and assert damages or obtain some kind of injunctive relief just based on the future risk. So it's another area that you need to be looking at it. And they're aggressively policing this data security issue. Now the key drivers in data breach lawsuits, and you're going to hear from us through the course of these 4 different seminars, a little piece on each of these. But you got to have, the first is a strong security posture. The second is an incident management plan. The third is a centralized management of data protection. And this is actually having someone designated within your company, either a person or a committee, to deal with data protection. And then finally, that consultants were engaged quickly to come in and help determine if a breach occurred, to determine the extent of the breach, and then to help out with the notification. These 4 drivers are all things that improve the outcome during data breach litigation. Now, there are also some drivers that have a negative effect. The first being this factor where breaches were caused by a third-party error, and that includes hacking or just inadvertent disclosure by, say, a third party by a vendor. In cases where you've got third-party error, the damages numbers go up, and it adversely affects your ability to defend this type of suit. Another negative driver deals with lost or stolen devices. You could see when we went through the standing analysis and the 12b6 analysis that where you had stolen information versus lost information, the courts are more inclined to let those cases go through. And again, the damages that result at the end of the day are much higher for stolen devices as opposed to lost devices. And then finally, this issue of notification of the breach victims. And again, it's not a failure to notify the breach victims that causes an increase in the damages. It's the notification too soon. And so you need to be measured when you have this type of thing. You don't want to have the knee-jerk response. You want to make sure that you thoroughly investigate it, that you hire your consultants, that you hire a law firm, and make sure that you're doing everything that you need to do before you send out that letter so that you don't end up upsetting customers and running them off. Or worse, having them run off to a law firm. And then this is just a metric showing exactly what we just talked about. So I realize I've been talking super fast and I had a lot to kind of get through, but at the end you'll see I've got a bibliography, so if you want to see some of the cases, if you want to see some of the papers, those are available. I can get you copies if you want to see the actual documents. I will just, before I stop, just point out a couple things. Moore Van Allen does have a privacy practice group. This is the group that's putting on this seminar series. We're a multidisciplinary group. We're not just litigators. We're IP lawyers. We're general litigators. We're employment litigators. We're also business lawyers and healthcare lawyers. So we cover sort of a wide variety of industries within the legal profession. This is just a silly little... Who do we deal with? Well, we deal with all levels of your company. IT guys, in-house counsel, privacy officers, practice administrators, executives, HR, you name it, we sort of cover the gambit. How can we help? We can help with everything from the management of data breach investigations, negotiating contracts and licenses. I will say this is a really important and novel area that you need to think about. What are your third-party vendors doing? Are they doing enough to protect the data that they obtain from your company? You need to make sure that they have proper security measures in place, and you also need to make sure that these third-party vendors have insurance coverage that applies to data breach. Because we've seen a lot of cases where a third-party vendor is actually the company that has the lax security. They're the ones that suffer the data breach, and then it's imputed on your company because you didn't do enough due diligence to make sure that the third-party vendor had their ducks in a row. And if they don't have insurance coverage, the plaintiffs are going to come looking to your company to pay for that. We help with advice, policy developments with HIPAA, responding to complaints with Office of Civil Rights, assisting with the U.S. EU Safe Harbor, as we talked about. You'll hear more about that in the series. EU data privacy, defending, pursuing claims for breach of privacy, advice, and then you can read on here. But the point is that I think Moore & Van Allen, through the creation of this privacy group, we are seeking to be able to provide each of you with a top to bottom privacy protection, and hopefully we can address any of the issues that you encounter within your industry. So with that, I'll stop. Does anybody have any questions? Again, I apologize I was talking so fast. It was a lot of information to go through. If you don't want to raise your hand, I'll be around here for a while and I can answer them afterwards. You have a question?
Can you go back a couple of slides? You just said something I had not heard. One more.
Okay.
Okay, one more.
Oh,
What
you
is-
make one more slide.
What
There.
is the Office of Civil Rights? That's a new, who is that?
That's a good question. Karen, the Office of Civil Rights, do you know who is handling complaints and inquiries from that?
Who within our first,
Well, no, I mean, what is it?
Do you know what it is? I don't know what it is. I have to be honest.
oh yeah, it's part of the Department of Health and Human Services, so it's in the.
Oh, okay.
Well, with that, thank you all very much for coming. We appreciate you taking the time out of your day, and we'll be here to answer any questions. Thank you.